Maritime Academy. Law of Marine Insurance, Part 7. Warranties. General principles. There are two types of warranties identified by the Act: express and implied warranties. A warranty in marine insurance, whether express or implied, is indeed a very special term of the contract. In the law of marine insurance, a warranty is also referred to as a promissory warranty, and this is made clear by Section 33(1), which defines a warranty to mean a promissory warranty, that is to say, a warranty by which the assured undertakes that some particular thing shall or shall not be done, or that some condition shall be fulfilled, or whereby he affirms or negatives the existence of a particular state of facts. There are certain features common to both express and implied warranties laid down by case law and the Act relating to the nature of a marine insurance warranty and the effect of its breach. These qualities have bestowed upon it its undoubted strength and importance as a contractual term. A promissory warranty does not have to be material to the risk. A promissory warranty must be exactly complied with. There is no defense for a breach of a promissory warranty. A breach of a promissory warranty is irremediable. A causal connection between breach and loss need not be shown. A breach of a warranty automatically discharges the insurer from liability, and a breach of a warranty may be waived. Each of the above general principles will be examined separately, followed by a discussion of some of the standard examples of express warranties and then the implied warranties. Materiality to the risk. There can be no question of querying the materiality of a warranty. A warranty does not have to be material to the risk. This is what distinguishes it from non-disclosure and misrepresentation. This aspect of the law is more appropriate to an express rather than to an implied warranty, the materiality of which cannot be called into question, being implied by law. Section 33(3) states that it must be exactly complied with, whether it be material to the risk or not. The law on the subject is more than well established. Exact compliance. The most demanding characteristic of a promissory warranty, whether express or implied, is that it must be exactly complied with. Unlike a representation, Section 33(3) insists upon a literal compliance. Substantial observance is not good enough. The use of the word must in Section 33(1) strengthens this requirement. A representation of fact need only be substantially correct, Section 24, and a representation of expectation or belief is true if made in good faith, Section 25. The severity of the rule of literal compliance can be seen in the case of Overseas Commodities Limited versus Style, 1958, where the question of severance of contract was also discussed. The facts of the case involved a cargo of canned pork insured under an all-risks policy which contained a warranty, warranted all tins marked by manufacturers with a code for verification of date of manufacture. The court held that there was a breach of warranty in that a substantial number of tins were not marked with a code in accordance with the warranty. Mr. Justice McNair was not prepared to grant the assured indemnity even for the tins that were properly marked in compliance with the terms of the warranty. The whole basis of his decision rested upon the ground that there was only one policy of insurance for the whole consignment of the goods, and that the contract of insurance could not be severed into as many contracts as there were tins of pork that were covered by that policy. He was adamant that the contract of insurance should not be rewritten in order to provide coverage for some of the loss. No defense for breach. With the exception of the two excuses laid down in Section 34, there is clearly no defense for a breach of an express or implied warranty. Though not specifically spelt out by the Act, the general principle that there is no defense for a breach of a warranty is firmly established by the common law. As there is nothing in the Act which is inconsistent with this rule, it shall continue to apply to contracts of marine insurance. Moreover, as only two excuses are laid down by the Act, they must be regarded as the only exceptions to the general rule allowed by law. The application of the general rule is actually best illustrated in cases relating to a breach of the implied warranty of seaworthiness. Lord Eldon in Douglas v. Scougal, 1816, in reference to the implied warranty of seaworthiness, stressed that it is not necessary to inquire whether the owners acted honestly and fairly in the transaction, for it is clear law that however just and honest the intentions and conduct of the owner may be, if he is mistaken in the fact, and the vessel is in fact not seaworthy, the underwriter is not liable. In Forshaw v. Chabert, 1821, the position was stated as follows: now it is clear that a ship must be seaworthy at the time when she sails. The assured warrants that, and whatever physical necessities may interpose, he is not allowed to deviate from the strict terms of his warranty. These cases, which have firmly established that there is no defense for a breach of the implied warranty of seaworthiness, have led the said warranty to be described as being absolute in nature. In this sense, the same may be said of all warranties. Excuses under Section 34(1). As mentioned earlier, there are only two statutory excuses contained in Section 34(1), which may be pleaded as a defense for non-compliance of a warranty: a change of circumstance, and when compliance with the warranty is rendered unlawful by any subsequent law. The excuse of a change of circumstance is more relevant to an express warranty than to an implied warranty, though, as worded, the section applies to both. In respect of the defense of illegality, Section 34(1) complements Section 41, which implies a warranty of legality in all polices, that not only the adventure, but the performance of the adventure has to be lawful. Breach is irremediable. Another defense to the effect that the breach of the warranty was remedied before the loss was unsuccessfully pleaded in relation to the implied warranty of seaworthiness in Quebec Marine Insurance Co. versus the Commercial Bank of Canada, 1870, the classic authority on the subject. Counsel for the assured suggested that as the defect was remedied before the loss occurred, the underwriters will remain liable. This defense, described as a proposition of perilous latitude, was rejected by the Privy Council. The principle of law, now contained in Section 34(2), declares that where a warranty is broken, the assured cannot avail himself of the defense that the breach has been remedied and the warranty complied with before loss. Causal connection not required. The fact that a breach of a warranty has no causal connection with the loss whatsoever is also immaterial. In Foley v. Tabor, 1861, Chief Justice Early's address to the jury on this point was, "It is not necessary for the insurer to make out that the loss was caused by the unseaworthiness relied upon. The question depends upon the state of the ship at the time when she sailed upon her voyage. The fact that the breach of a warranty has not caused the loss is clearly of no consequence. Automatic discharge from liability. Section 33.3 states that a warranty is a condition which must be exactly complied with. Though called a warranty, it is in fact, as defined by the said section, a condition of a promissory nature. Thus, promissory condition would be a more suitable name for it. The word condition is not defined in the Act. It is, however, capable of two meanings. It could be used in the lay or non-technical sense to mean a provision, a requirement, or simply a term of the contract, which in this case must be exactly complied with. Or it could be interpreted in a strict and purely legal sense as understood in the general law of contract as a particular type of contractual term, a condition as opposed to a warranty or innominate term. Under ordinary contract law, a warranty is a term of a contract, the breach of which would bestow upon the innocent party the right only to damages. Once a breach of a promissory warranty has been committed, the result is automatic. The insurer is spontaneously and automatically discharged from liability as from the date of the breach, but without prejudice to any liability incurred by him before that date. The future of the contract. In relation to a warranty on geographical limits, the second of the above consequences of a breach of a condition precedent is particularly significant to the question of whether a ship which has entered and departed from a prohibited area is covered for a loss of or damage sustained whilst traversing outside the prohibited area during the currency of the policy. In other words, is the policy revived or restored on the ship leaving the prohibited area? If the rule of automatic discharge is to be carried to its logical conclusion, the insurer would be discharged from liability on the ship, taking the very first step of entering the prohibited zone. The moment she enters the prohibited area, the insurer is automatically discharged from liability or further liability. This would mean that unless the breach was waived, any damage suffered by the vessel thereafter, wherever and however sustained, would not be covered by the policy. Unless such a clause is construed as a limitation of cover, there is no question of a suspension of the policy. A promissory warranty is thus a special kind of condition precedent, the breach of which automatically discharges the insurer from liability without the insurer having to take steps to rescind the contract, which he would have to do so in the case of a breach of an ordinary condition. As the insurer is entitled to refuse to perform or accept performance from the party, the shipowner, in breach, the policy is in practical terms at an end. Unless the breach is waived, there is no future for the contract. In this respect, the effect of a breach of a promissory warranty is no different from that of a breach of a condition. The difference is that in the case of the former, it is not dependent upon a decision by the insurer to rescind the contract, whereas in the latter, he has to take steps to end the contract. A cross of two contract law concepts, namely a condition and a condition precedent, is inherent in Lord Gough's proposal. The marriage of one, strained from a condition with another from a condition precedent, has produced a new hybrid of contractual term, yet to be given a name of its own in the general law of contract. In marine insurance law, it is known as a promissory warranty. The legal position is somewhat peculiar in the sense that in the event of a breach of a promissory warranty, the contract is neither void nor avoidable. It is by no means void, as rights and liabilities accrued before the breach are expressly preserved by the Act. Neither is it voidable, as the insurer does not have to take the initiative to rescind the contract. Further, the contract is neither suspended nor brought to an end. An insurer who does nothing after a breach of a promissory warranty can now no longer be accused of having, by his inactivity, impliedly waived or affirmed the contract. In the absence of some overt act on his part demonstrating an intention to waive the breach, the insurer is automatically discharged from all future liability. Waiver of breach of warranties. Section 34(3) permits an insurer to waive a breach of warranty. Such a course of action, which is normally achieved by the insertion of either a held covered or a waiver clause, is also recognized by the phrase subject to the provisions in the policy in Section 33(3). It is to be noted that the implied warranty of legality laid down in Section 41 cannot be waived. Held covered clause. A held covered clause is a device which an assured could rely on to protect himself in the event of a breach of a warranty. Under Clause 3 of the ITCH 95, breach of certain warranties, namely as to cargo, trade, locality, towage, salvage services, or date of sailing, is held covered by the policy, provided that the assured complies with the conditions laid down therein. In the case of the IVCH 95, any breach of warranty as to towage or salvage services is held covered, provided that notice be given to the underwriters immediately after receipt of advices and any amended terms of cover and any additional premium required by them be agreed. Once the specified terms are complied with, the breach is waived and the assured is entitled to claim for the loss. Express warranties. Form of warranty. An express warranty, according to Section 35, subsection 2 of the Act, must be included in or written upon the policy, or must be contained in some document incorporated by reference into the policy. Thus, provided that there is an intention to warrant, answers to questions contained in slips, proposal forms, or covering notes, P and I Club rules and declarations and statements of fact can all become warranties if they are inserted or incorporated either directly or indirectly by way of reference into a policy. A warranty may be expressed in any form of words. There is no special or formal wording in which it must be drafted. Thus, provided that an intention to warrant is manifested, any written statement may be construed as a warranty. The word warranted, however, is often used to preface an express warranty, but this does not mean that if the word warranted is not used, an express term cannot be construed as a warranty. Unfortunately, the term warranted has also been used to secure for the insurer exception or limitation of cover. Like any other contract, the express terms in contracts of marine insurance are varied. They may be broadly divided into 4 categories. Exception clauses, mere words of description identifying or qualifying the subject matter. Limitation of liability clauses defining the scope of the insurer's liability. Promissory warranties. It is important to bear in mind that not all the express terms of a contract of insurance are warranties. Exception clauses. Exception clauses in marine insurance are often prefaced with the words warranted free of. The use of the expression warranted in exception clauses has in the past generated a degree of confusion as to whether such terms are in fact warranties. E.g., warranted free of particular average. In Nova Scotia versus Hellenic Mutual War Risks Association, Bermuda, Ltd., The Good Luck, 1991, Lord Goff distinguished between those warranties which simply denote the scope of the cover, as in the familiar FC and S clause, warranted free of capture and seizure, and those which are promissory warranties, involving a promise by the assured that the warranty will be fulfilled. Perhaps it needs to be mentioned that in the case of an exception clause, causation plays an important role. Only a loss proximately caused by the accepted peril is not covered by the policy, whereas in the case of a promissory warranty, the cause of a loss is totally irrelevant. This is indeed a fundamental distinction between an exception clause and a promissory warranty, with the exception of Section 36(2). As a rule, a breach of a promissory warranty does not have to cause the loss. However, with regard to the implied condition of proper documentation, the loss has to occur through a breach of this condition before the insurer is entitled to avoid the contract. Descriptive warranty. Words describing or qualifying the subject matter insured are particularly susceptible to being classified as a promissory warranty. The distinction between a warranty and mere words of description is best illustrated in the case of Overseas Commodities Limited versus Style, 1958, to which reference has already been made. Mr. Justice McNair held that the identification number which the tins of pork butts were to be marked was not a warranty, but were mere words of description for the purpose of identifying the goods. The policy only attaches to such of the goods that comply with the description. In contrast, the term expressed as warranted all tins marked by manufacturers with a code for verification of date of manufacture was held to be a warranty. As a rough guide, it is perhaps fair to say that a description inserted merely for the purpose of identifying the subject matter, having no relation whatsoever to the risks insured against in the particular policy, is not a promissory warranty. Each case, of course, has to be decided on its own facts. Limitation of liability clause. The line between a clause limiting the liability of the insurer and a promissory warranty is sometimes not so easy to draw, and a degree of disarray is evident in this area of the law of marine insurance, which will soon become obvious in the discussions to follow on warranties on trading or navigational limits. Examples of express warranties. It is impossible and a futile exercise to describe all the different types of promissory warranties that are employed in marine policies. For the purpose of illustration, the two express warranties identified by the Act, namely the warranty of neutrality and of good safety, the disbursements warranty, the towage and salvage warranty, the new classification clause of the ITCH 95 and the IVCH 95, and the well-known warranty on geographical limits of navigation will be examined. Express warranty of neutrality. Where a policy on ship or goods contains an express warranty of neutrality, Section 36 seeks to govern the express warranty by implying two terms to the express warranty, namely that there is an implied condition that the property shall have a neutral character at the commencement of the risk, and that so far as the assured can control the matter, its neutral character shall be preserved during the risk. And there's also an implied condition that so far as the assured can control the matter, she shall be properly documented, that is to say that she shall carry the necessary papers to establish her neutrality, and that she shall not falsify or suppress her papers or use simulated papers. If any loss occurs through breach of this condition, the insurer may avoid the contract. It is necessary to distinguish the effects of a breach of the two implied conditions. A breach of the first condition will naturally cause a breach of the express warranty of neutrality. This will trigger Section 33, subsection 3, to discharge the insurer from liability as from the date of the breach. A breach of the second implied condition as regards proper documentation will, on the other hand, confer upon the insurer the right to avoid the contract. But this can only take place if the loss has occurred through a breach of this condition. In other words, causation, though not generally relevant to a breach of a warranty, is relevant here. The insurer can avoid the contract only if the loss occurs through or was caused by a breach of the condition. Express warranty of good safety. Very little need be said about Section 38 on the warranty of good safety, except that the expression good safety is also used in Rule 3 of the Rules for Construction. Section 38 states that if the subject matter insured is warranted well or in good safety on a particular day, it is sufficient if it be safe at any time during that day. Disbursements warranty. The ITCH 95 and the IVCH 95 each has a warranty relating to disbursements contained in Clause 22 and 20 respectively. This warranty was originally introduced pursuant to the Gunford case, 1911, discussed earlier. The purpose of the warranty is to limit the amount of insurance which the owner of a vessel may effect on disbursements, managers' commissions, and a list of other items. It is now possible to insure up to 25% of the valuation stated in the policy in respect of these enumerated matters. The given percentage is to ensure that he does not over-insure by double insurance. Thus, he may safely insure up to the percentage permitted without having to make a disclosure of the additional insurances to the insurer. Clause 22.1.8 of the ITCH 95, however, permits the assured to insure irrespective of amount against the risk excluded by the war, strikes, malicious acts, and the radio contamination exclusions. Clause 24 to 27. The purpose of Clause 22.2 of ITCH 95 is to protect an innocent mortgagee who has no knowledge of the breach of warranty from recovering under the policy. The insurer is prevented from setting up the breach committed by the ship owner as a defense against any claims made by a mortgagee. Towage and salvage warranty. The above warranty on towage and salvage is tucked away in the navigation clause, Clause 1.1 of both the ITCH 95 and the IVCH 95. By Clause 1.1, customary towage and towage to the first safe port or place when in need of assistance are accepted and therefore are not covered by the warranty. As the scope of Clause 1.1 has already been fully discussed, very little need be said about the warranty here, except that it is also governed by a held covered clause known as the breach of warranty clause, Clause 3, in the ITCH 95, and the change of voyage clause, Clause 2, in the IVCH 95. In the event of any breach of warranty as to towage and salvage services, the assured is held covered provided that notice be given to the underwriters immediately after receipt of advices, and any amended terms of cover and any additional premium required by them be agreed. By the new clause 1.2 of the 1995 version of the ITCH, any contracts entered into by the assured for towage or pilotage services, which are either customary or compulsory, will not prejudice the insurance. The clause acknowledges the fact that the assured or their agents may have to enter or be compelled to enter into such contracts in accordance with established local law or practice. The insurance shall not be prejudiced, even if the said contracts entered into may have limited or exempted the liability of the pilots and or tugs and or towboats and or their owners. The classification clause. The new clause 4.1, The classification clause of the ITCH 95 requires that the vessel be classed with a classification society agreed by underwriters and to remain in class, and the classification society's recommendations, requirements, and restrictions regarding seaworthiness and of her maintenance thereof be complied with by the dates set by the society. One of the objectives of the clause is to improve safety standards of vessels. It also demonstrates the underwriter's support of the endeavors of classification societies in promoting the seaworthiness of ships. The intention of the clause is to not only to ensure that an assured complies with the rules of classification society, but more importantly, that a reputable classification society, one agreed by the underwriters, be used. A warranty. Though not described as a warranty, and the word warranted does not appear in the clause, Clause 4.1 can nevertheless be classified as a warranty if there is an intention to warrant. Furthermore, in the event of breach of any of the duties set out in Clause 4.1, the underwriters will be discharged from liability as from the date of the breach. Thus, the effect of a breach of Clause 4.1 is the same as that stipulated in Section 33(3) of the Act. The words, "unless the underwriters agree to the contrary in writing," suggest that it is possible to waive the breach. As a warranty, its terms must be exactly complied with, and its breach will attract the operation of the law, as set out in the case of the Good Luck, 1991. The failure to comply would automatically discharge the insurer from liability, even if such failure does not result in a claim or its breach did not cause the loss. This is so unless the vessel is at sea at the time of breach, in which case the underwriters are discharged from liability upon her arrival at her next port. It is to be noted that the duty imposed on the assured owners and managers is a continuous duty commencing from the inception of and running throughout the period of the insurance. Class and maintenance of class. By Clause 4.1.1, the vessel must be classed with a classification society agreed by the underwriters, and that her class within that society is maintained. In other words, any change of class or of classification society without the agreement of the underwriters would constitute a breach. It is observed that the word that is significant, the vessel, has to maintain not only her class, but her class within that society. Recommendations, requirements, and restrictions of classification society. It needs to be emphasized that only recommendations, requirements, or restrictions imposed by the vessel's classification society pertaining to the vessel's seaworthiness or to her maintenance in a seaworthy condition have to be complied with. Whether or not a particular recommendation, requirement, or restriction relates to seaworthiness is a problem which is likely to arise. The meaning of seaworthiness has thus to be clear in one's mind. What the position would be if an extension were to be granted to the assured by the classification society for compliance with their recommendation, etc., is not clarified. Presumably, there will be no breach if the date of the extension is complied with. Reporting to classification society. Clause 4.3 imposes a duty upon the assured to report to the classification society any incident, condition, or damage in respect of which the vessel's classification society might make recommendations as to repairs or other action to be taken by the assured, owners, or managers. The difficulty here lies in the word might. It would appear that an assured is expected to be able to anticipate what his classification society might or might not do in a particular circumstance. Clause 4.3 is peculiar in the sense that there is no sanction spelt out for its noncompliance. Authorization for release of information. The purpose of Clause 4.4 of the ITCH 95 is to enable the underwriter to obtain information directly from the classification society, which, without necessary authorization from the assured, is not obliged to divulge on the ground of the principle of privity of contract. Through this facility, the underwriter hopes to obtain vital information regarding the condition of the ship. Some thought may perhaps have to be given to the question of whether the assured has the power to make such an authorization unilaterally without first obtaining the consent of the classification society. Again, as in the case of Clause 4.3, there is no penalty given for a breach of this clause. What would be the legal effect if the classification society were to refuse to comply with an authorized request of the underwriter for information and/or documents? Warranties on geographical limits of navigation. A breach of a warranty cannot bring about a suspension of the contact of insurance because the insurer is automatically discharged from liability in the event of a breach. The fundamental difference between a promissory warranty and a clause which defines the liability of the insurer is that a breach of the former discharges the insurer from liability, whilst in the case of the latter, the contract is merely suspended. One cannot help but notice that none of the marine insurance cases has queried what the understanding of the parties of the clause was. The purpose of inserting such a clause was never ascertained, and whether its wording was clear enough to permit an inference to be drawn that there was an intention to warrant was never explored. The question which should have been asked is whether it was the understanding of the parties that the future of the whole contract of insurance is conditional upon the assured not entering the prohibited area. However worded, it is the intention of the parties which is crucial. If these issues had been debated before the courts, one would perhaps accept the current legal position with less resistance. However, it could be said that, having been accepted as a warranty for almost 150 years, it is now probably too late in the day to turn the clock back. It has by usage come to be known as a warranty. The decisive consideration has to be whether it is the intention of the parties to exact or to give a warranty. In this regard, it would be prudent to bear in mind the words that a great deal turns upon the language of the particular policy. But it must be remembered that in contracts of insurance, the word warranty does not necessarily mean a condition or promise, the breach of which will avoid the policy. The word avoid will now have to be read as automatically discharge. The Institute Warranties. The Institute Warranties 1776 contain a list of warranties relating to geographical limits of navigation. Navigation is prohibited during certain months of the year within certain areas, the parameter of which is defined by degrees of latitude and longitude. In practice, a trading limits warranty is invariably accompanied by a held covered clause, the purpose of which is to allow an assured the right to obtain cover whilst navigating within the prohibited area, provided that prompt notice is given and additional premium arranged. The rule of contra proferentum. It is a well-known principle of insurance law that if the language of a warranty in a policy is ambiguous, it must be construed against the underwriter who has drawn the policy and has inserted the warranty for his own protection. Whenever there is ambiguity in a warranty, a court may employ any one or more of the above basic rules of construction to give it a sensible and plausible meaning. Rather than be the cause of bringing the contract to an end, A court would be more inclined to give a reasonable interpretation to a term. If necessary, the term would be construed against the underwriter for whose benefit it was inserted. A sensible balance has thus to be struck, but a court must never be seen to be rewriting the contract for the parties. Implied warranties. An implied warranty is a term of a contract regarded by law as so obviously essential and fundamental to the contract that the parties must have presumed that it applies without having to make any express provision for it. So indispensable is the term that it is tacitly understood that it is to be read into the policy even though it does not appear on the face of it. There are 4 warranties implied by the Act. The implied condition of proper documentation is only implied when the policy contains an express warranty of neutrality. Section 36(2). Implied warranty of portworthiness, Section 39(2). Implied warranty of seaworthiness, Section 39. Implied warranty of cargo worthiness, that is, the fitness of the ship to carry the goods, Section 42, and implied warranty of legality, Section 41. Curiously, in Section 37 there is no implied warranty as to the nationality of a ship, or that her nationality shall not be changed during the risk, and in Section 41 that there is no implied warranty that the goods or movables are seaworthy. Implied warranty of portworthiness. As was seen, the subject matter may in a voyage policy be insured either from or at and from a particular place. In a from policy, only a single warranty that of the implied warranty of seaworthiness applies at the commencement of the voyage, whilst in an at and from policy, the ship has, in addition to the implied warranty of seaworthiness, to comply with the implied warranty that she be reasonably fit to encounter the ordinary perils of the port, that is, she be seaworthy for the port or portworthy. In a policy which attaches while the ship is in port, namely an at and from policy, the ship, according to Section 39(2), has to comply with the implied warranty that she shall at the commencement of the risk be reasonably fit to encounter the ordinary perils of the port. Section 39(2) is obviously not applicable when the subject matter is insured from a particular place, for the risk under such a policy does not attach while she is at that port, unless expressly excluded by the policy. Section 39(2), like Section 39(1), is worded to apply to all voyage policies, whether on ship cargo or freight. Whether a ship has to be fit enough to endure the ordinary perils of the port throughout the period of her stay whilst at that port is an issue which has never been raised. Unlike the implied warranty of seaworthiness, there is no litigation concerning this implied term. As the implied warranty of seaworthiness is applicable only at the commencement of the voyage, it could be said that the implied warranty of portworthiness should likewise apply only at the commencement of the risk. The wording of Section 39(2) is sufficiently clear to support the assumption that the ship need only be portworthy at a specific point in time. In the case of an at and from policy on a ship, the risk, according to Rule 3, attaches or commences only when she has arrived at that place in good safety. The implied warranty of portworthiness thus coincides with the attachment of the risk, which occurs only when the ship is in a state of good safety at that port. At that particular moment when she is in good safety, she has to be sound enough to be in port without being at risk from the ordinary perils of the port. Whether a ship is or is not reasonably fit to encounter the ordinary perils of the port is of course a question of fact. Implied warranty of seaworthiness. The Act implies a warranty of seaworthiness in a voyage policy, but not in a time policy. This does not, however, mean that the unseaworthiness of a ship insured under a time policy is totally irrelevant. A different set of rules, declared in Section 39(5), applies to time policies. Implied warranty of seaworthiness in voyage policies. Section 39(1) declares in general terms that in a voyage policy, there is an implied warranty that at the commencement of the voyage, the ship shall be seaworthy for the purpose of the particular adventure insured. Subject matter insured. The section does not specify the nature of the subject matter insured. As worded, it is wide enough to be construed as being applicable to all voyage policies, regardless of the nature of the subject matter insured, whether it be ship, goods, freight, or any property exposed to maritime perils. In the case of a policy on goods or other movables, however, there is also another section dealing specifically with this implied term, where the general rule declared in Section 39(1) is reaffirmed in Section 42 as follows. In a voyage policy on goods or other movables, there is an implied warranty that at the commencement of the voyage, the ship is not only seaworthy as a ship, but also that she is reasonably fit to carry the goods or other movables to the destination contemplated by the policy. Meaning of seaworthiness. It may be helpful before proceeding to analyze the nature and scope of this implied warranty first, to define the meaning of the term seaworthiness. Needless to say, this discussion of definition is also relevant to a time policy, as the word seaworthy also appears in Section 39(5). There are essentially two criteria by which the seaworthiness of a ship may be measured. The first is espoused in Section 39(4), which determines the seaworthiness of a ship by her ability to encounter the ordinary perils of the sea of the adventure insured. The second, a common law criterion, uses the standard of the ordinary careful and prudent ship owner. Ability to encounter the ordinary perils of the seas. Section 39(4) provides a broad and general definition that a ship is deemed to be seaworthy when she is reasonably fit in all respects to encounter the ordinary perils of the seas of the adventure insured. The ship's fitness to encounter the ordinary perils of the seas of the voyage is universally accepted as the test for determining the seaworthiness of a ship. The two words in the statutory definition, which require elaboration, are reasonably and ordinary. The former refers to the standard of fitness, whilst the latter describes the perils of the seas. Standard of reasonable fitness. It is significant to note that the standard of fitness is not one of perfection, but only of reasonableness. To be seaworthy, a ship is not expected to be able to weather every conceivable storm or withstand every imaginable peril of the sea. All that is required of her is that she be reasonably suitable for the particular voyage. For example, a ship which sets sail with an open porthole would clearly fail to satisfy the standard of perfection, but would be quite acceptable according to the standard of reasonable fitness. Similarly, the fact that a master is not expected to be in a state of perfect health was appreciated in the case Rio Tinto Co. Ltd. versus the Seed Shipping Co. Ltd. 1921. Ordinary perils of the seas. That the ship need only be fit enough to encounter the ordinary, not extraordinary perils of the seas is another well-established aspect of the implied warranty. She need only to be capable of withstanding the normal vicissitudes of the voyage. What, in each case, is an ordinary peril of the sea was explained in Kopitov versus Wilson and the Gopian, No. 3, 1876. In the former, incidental risks to which a ship must of necessity be exposed in the course of the voyage were considered ordinary perils of the seas. In the latter, heavy weather of the kind expected of the voyage was held to fall within the scope of an ordinary peril of the seas. Thus, even severe weather, hurricanes, cyclones, and strong gales could be considered as ordinary perils of the seas if they are conditions expected of a particular region. In accordance with Rule 7 of the Rules for Construction, the term perils of the seas refers only to fortuitous accidents or casualties of the seas. It does not include ordinary action of the winds and waves. The ordinary careful and prudent shipowner criterion. The test is direct, objective, and simple to apply. A ship is seaworthy if an ordinary, careful, and prudent owner would send her to sea in her present condition. Though Section 39(4) has provided its own test for the purpose of ascertaining seaworthiness, there is no reason why the common law standard of the prudent shipowner could not also be invoked. A combined application of both methods was employed by Mr. Justice Earl in Gibson versus Small, 1927, as follows. Seaworthiness expresses a relation between the state of the ship and the perils it has to meet in the situation it is in, so that a ship before setting out on a voyage is seaworthy if it is fit in the degree which a prudent owner uninsured would require to meet the perils of the service it is then engaged in, and would continue so during the voyage unless it met with extraordinary damage. A relative term. Seaworthiness is a relative and flexible term. It varies according to the nature of the voyage contemplated. Thus, a ship may be seaworthy for one voyage, but not for another. There is no fixed or absolute standard of seaworthiness, and the wording of Section 39(1) itself makes this clear. It states that the ship shall be seaworthy for the purpose of the particular adventure insured. Specific matters relating to seaworthiness. An analysis of cases will reveal the fact that there are 6 aspects of a ship which can affect or impinge upon her seaworthiness. These matters relate to design and construction, machinery, equipment, and navigational aids, sufficiency and competence of crew, sufficiency and quality of fuel, spare parts and stores, stability and stowage of cargoes, and certification and documentation. At the commencement of the voyage. It is important to remember that the implied warranty of seaworthiness is applicable only at a particular time, that is, at the commencement of the voyage, regardless of whether the policy is from or at and from a particular place. The implied warranty of seaworthiness applies only when the ship sets sail from that particular place. She does not have to be seaworthy for the voyage while she is lying in port. But once the warranty is fulfilled, the ship owner's obligation to the underwriter is at an end. There is no continuing warranty of seaworthiness. Whether a voyage has or has not commenced is, of course, a question of fact. A ship has to break ground and quit her moorings with the intention of embarking upon her voyage before she can be said to have commenced her voyage. Thus, a mere intention to commence a voyage is inconsequential. Seaworthiness by stages. The implied warranty of seaworthiness, though expressly stated to be applicable only at the commencement of the voyage, meaning the insured voyage has to be read in the light of the doctrine of seaworthiness by stages, as defined in Section 39(3). This is yet another declaration of a well-founded common law principle, which is also applicable in the law of contracts of affreightment. It is observed that under some jurisdictions, the courts are reluctant to extend the boundaries of the doctrine of seaworthiness by stages. It has invariably been restricted to matters of necessity for commercial, physical, or practical reasons. The courts have always jealously guarded the limits of its application, confining it only to cases of refueling, and when circumstances justify its application, such as when the ship requires different kinds of or further preparation or equipment, there has to be a physical or commercial need to warrant a division of the voyage into stages. Effective breach of implied warranty of seaworthiness. As was seen earlier, a promissory warranty in marine insurance is in fact a condition precedent, the breach of which automatically discharges the insurer from liability as from the date of breach. This rule applies to all promissory warranties, including the implied warranty of seaworthiness. In a voyage policy from a particular place, no liability can be incurred before the commencement of the voyage, because the policy attaches only when the ship sets sail from that particular port in compliance with the implied warranty. In this context, it is true to say that it is a condition precedent to the attachment of the risk. In the case of an at and from policy, however, the position is different in the sense that the policy had already attached when the ship arrived at the particular port in good safety. Any loss occurring before the vessel sets sail whilst the vessel is at that place would thus fall upon the policy. Should a breach of the implied warranty of seaworthiness be committed later, when she sets sail, the insurer is only discharged from liability, as from the date of breach, but without prejudice to any liability incurred by him before the breach. Exclusion of the implied warranty of seaworthiness. The warranty of seaworthiness, absolute in its nature and capable of producing a most disastrous effect upon a policy in the event of its breach, is an important safeguard for the preservation of life at sea. Yet its creator, regarding it to be the bounden legal duty of the shipowner towards the mariners for the safety of their lives and towards the merchants who load their goods to furnish a seaworthy ship, has also deemed it fit to allow for its exclusion in a policy of marine insurance. To exclude the application of the implied warranty of seaworthiness in a voyage policy, the parties to the contract of insurance may either employ the use of an exception clause or waive the breach as allowed by Section 34(3) of the Act. Exception clauses. A clause stating that the ship was to be allowed to be seaworthy for the voyage was used in Phillips and Another versus Nairn and Another, 1847. The effect of such a clause was held to have relieved the owner of the obligation to comply with the implied warranty of seaworthiness. The allowed to be seaworthy clause was later replaced with the seaworthiness admitted clause, which was more directly expressed. Both have now fallen into disuse, but in relation to cargo, the unseaworthiness and unfitness exclusion clause, Clause 5, of the ICC A, B, and C could be described as the modern equivalent. Clause 5.1 is clearly not concerned with the implied warranty of seaworthiness. It is an exception clause, excluding the insurer from liability for a loss arising from unseaworthiness to which the assured or his agents are privy. At the time the subject matter is loaded on board the ship, it maintains cover against loss for all other types of unseaworthiness, which arise after the initial implied warranty of seaworthiness applicable at the commencement of the voyage has been complied with. If the implied warranty of seaworthiness is not fulfilled, there can be no question of accepting the insurer from liability because he would have been automatically discharged from further liability under the contract as from the date of breach, that is, at the commencement of the voyage. The legal effect produced by Clause 5.1 is as follows: provided that the assured or his servants are not privy to such unseaworthiness at the time the subject matter is loaded, he is insured for any loss arising from the unseaworthiness of the vessel. Held covered clause. Whilst on the subject of the held covered clause, all that needs to be mentioned here is that Clause 3 of the ITCH 95 and Clause 2 of the IVCH 95 are of limited application and do not apply to the implied warranty of seaworthiness. Thus, a ship owner who wishes to protect himself from the consequences of a breach of this warranty would have to insert a clause specially for this purpose. Otherwise, all he can hope for is for the insurer to waive the breach. Unseaworthiness and the Inchmary clause. A latent defect in hull or machinery could well render a vessel unseaworthy, resulting in a breach of the implied warranty of seaworthiness. A latent defect is one which could not be discovered on such an examination as a reasonably careful, skilled man would make. As the implied warranty of seaworthiness is absolute in nature, the assured would not be able to plead as a defense the lack of knowledge of the defect. Any claim that he had exercised due care would be of no avail. However, Clause 6.2.1 of the ITCH 95 and Clause 4.2.1 of IVCH 95 provides insurance cover against loss of or damage to the subject matter insured caused by inter alia, any latent defect in the machinery or hull, with the proviso that such a loss or damage must not have resulted from the want of due diligence by the assured owners or managers or superintendents or any of their onshore management. The words in italics are not in the ITCH 83 or the IVCH 83. If it is to be given its full effect, an assured would be able to recover under the policy even though the implied warranty of seaworthiness has been breached by reason of the latent defect. Burden of proof. An insurer would naturally wish whenever possible to plead a breach of the implied warranty of seaworthiness as a defense to exonerate himself from liability to a claim. As he is making the allegation that the ship is unseaworthy, it is only fair and natural that he should bear the burden of proof. This is in accordance with the general principle of the law of evidence. He who alleges must prove, and the burden normally lies on the party who asserts the affirmative of the issue or question in dispute. Parker and others versus Potts, 1815, may be cited as the authority which has enunciated the general rule that a ship is prima facie to be deemed seaworthy. Thus it lies upon the insurer to prove the contrary. However, the burden of proof may well shift to the assured in certain circumstances. The circumstances under which the general rule may be displaced have to be examined, as such a shift in the burden of proof is an advantage of tactical importance to the insurer, who is now to be relieved of the duty which originally lies in him to provide evidence to show that the ship was unseaworthy when she set sail. A court would naturally, as far as possible, prefer to leave the initial burden where it lies, and it would rarely disturb the general rule of onus of proof unless the circumstances clearly permit. The particular facts of a case could invoke a presumption of unseaworthiness, albeit a rebuttable one, resulting in the shifting of the burden to proof to the assured, who would have to adduce evidence to refute the presumption. It is then incumbent upon the assured to show that the ship was in fact seaworthy when she set sail, and that her condition had arisen from cause or causes arising subsequent to the commencement of the voyage. No implied warranty of seaworthiness in time policies. English law does not impose a warranty of seaworthiness on a time policy. In America, the implied warranty applies to both time and voyage policies. Principle is now firmly consolidated in Section 39(5) of the Act, which declares that in a time policy there is no implied warranty that the ship shall be seaworthy at any stage of the adventure, but where with the privity of the assured the ship is sent to sea in an unseaworthy state, the insurer is not liable for any loss attributable to unseaworthiness. Though there is no implied warranty of seaworthiness in a time policy, this does not, however, mean that the question of seaworthiness is irrelevant. Surprisingly, there is hardly any litigation on this section. At any stage of the adventure, the above phrase was inserted to foreclose any arguments such as those raised in Jenkins v. Haycock, 1853, suggesting that a warranty of seaworthiness is applicable at the commencement of each and every intermediate voyage made during the currency of the time policy. These words have put at rest any doubts which one might have as to the applicability of the implied warranty at each intermediate voyage undertaken by the insured vessel. Privity. Privity means not only positive knowledge, but also the sort of knowledge expressed in the phrase turning a blind eye. If a man suspicious of the truth turns a blind eye to it and refrains from inquiry so that he should not know it for certain, then he is to be regarded as knowing the truth. This turning a blind eye is far more blameworthy than that of mere negligence. Negligence in not knowing the truth is not equivalent to knowledge of it. It needs to be said that it is the privity of the assured which is relevant. Thus, the knowledge must be that of the ship owner personally, or of his alter ego, or in the case of a company of its headmen, or whoever may be considered their alter ego. In other words, the right people must have the relevant knowledge. Attributable to unseaworthiness. First, it is to be noted that Section 39(5) does not use the words caused by or proximately caused by unseaworthiness. If unseaworthiness is the sole proximate cause of a loss, the insurer does not have to rely on Section 39(5) to free himself from liability. In a standard policy, unseaworthiness is not a peril insured against. Thus, regardless of whether the assured is or is not privy to the vessel's condition of unseaworthiness, such a loss is just not recoverable. To invoke Section 39(5), the loss has first to be brought under the policy. This means that it has to be shown that the loss is caused by an insured peril and is therefore prima facie recoverable. The insurer's defense would then be that the assured is to be disentitled of his right of claim by reason of his privity to the vessel's condition of unseaworthiness. As with the defense of willful misconduct under Section 55(2)(a), the expression attributable to appearing in Section 39(5) is specially chosen to cover the circumstance where unseaworthiness is either a remote cause of loss or where it is one of two or more proximate causes of loss, at least one of which is an insured peril. There would be no need to apply Section 39(5) if unseaworthiness is the sole proximate cause of loss, or where unseaworthiness is one of two or more proximate causes of loss, none of which is an insured risk under the policy. Particular unseaworthiness. The wording of Section 39(5) does not state whether the insurer is to be exempted from liability for loss attributable to any kind of unseaworthiness or only to the particular unseaworthiness to which the assured is privy when he sent the vessel to sea. This uncertainty was clarified in the Thomas Tyne and Ware case, where Mr. Justice Atkin, who had to contend with a ship which was unseaworthy in two ways: unfitness of hull, to which the assured was not privy, and an insufficient crew to which he was privy, observe that where a ship is sent to sea in a state of unseaworthiness in two respects, the assured being privy to the one and not privy to the other, the insurer is only protected if the loss was attributable to the particular unseaworthiness to which the assured was privy. As the assured was not privy to the particular unseaworthiness, unfitness of hull, which had caused the loss, the insurers were held liable for the loss. An insurer is to be held not liable for a loss attributable to unseaworthiness only to which the assured was privy. Implied warranty of cargo worthiness. Section 42 has imposed two implied warranties in a voyage policy on goods or other movables. There is an implied warranty that the ship on which the cargo is carried is seaworthy at the commencement of the voyage and reasonably fit to carry the good or other movables to the destination contemplated by the policy. That is, she is also cargo-worthy. As these provisions are now overridden by the unseaworthiness and unfitness exclusion clause, Clause 5, of the ICC A, B, and C, which has already been discussed earlier, very little need be said here about them except that the former relates to seaworthiness pertaining to the ship's ability to encounter the ordinary perils of the sea, whilst the latter is concerned with her capability to carry the particular cargo in question, commonly referred to as the implied warranty of cargo worthiness in the law of carriage of goods by sea. The familiar distinction between uncargo worthiness and bad stowage, however, needs to be drawn here. Bad stowage can, of course, cause a ship to become unseaworthy, but only if it affects her stability and ability to encounter the ordinary perils of the sea. But bad stowage which does not interfere with the ship's capability to combat ordinary sea perils is just pure and simple bad stowage and will not offend the implied warranties of seaworthiness or cargo worthiness. Though the ship has to be seaworthy, there is no implied warranty that the goods or movables have to be seaworthy or that they have to be able to endure the stresses or vicissitudes of the sea voyage. Implied warranty of legality. The implied warranty of legality is laid down in Section 41 as follows. There is an implied warranty that the adventure insured is a lawful one, and that so far as the assured can control the matter, the adventure shall be carried out in a lawful manner. It will be recalled that the subject of legality is also echoed in Section 3, where the words lawful marine adventure are used, as the wider word adventure and not voyage is used in Section 41. It has to apply to all policies, regardless of the nature of the subject matter insured, and the policy whether it be for time or voyage. Breach of the implied warranty of legality cannot be waived. Though Section 34(3) states that a breach of warranty may be waived nevertheless, it has to be pointed out that a breach of the implied warranty of legality is an exception to the rule. In this sense, the use of term warranty in Section 41 is incongruous when read with Section 34(3). End of Part 7. Maritime Academy